of how rights went wrong. He talks to Sreenivasan about the high stakes of America's constitutional conflict. Christian, thanks. Professor Jamal Greene, thanks for joining us. First, right now, every Supreme Court decision seems to boil down to fundamental rights. So what happens when I have a right and I take you to court because you say you have a competing right, and we decide that there's a winner and a loser? I mean, is there an in-between? Should there be?
Well, I certainly think there should be an in-between, and I think courts have at least implicitly understood that there should be an in-between. The fact of the matter is we live in a society in which we're pluralistic. We have very different views. We're diverse from each other. We have different values and commitments. And so the idea that you can just sort of take our competing rights and decide the Constitution believes in one of those rights but doesn't believe in the other is not consistent with the kind of society that we live in. And I think you're seeing that in the polarization that we see is everything gets kind of dialed up to 10 instead of trying to figure out ways of reconciling our competing rights. You know, saying that people have a right to go to the government to try to protect themselves from gun violence and also a right to own guns is something that has to be reconciled. It's not something that where you just pick one or the other, because that denies either the agency and the self-government of one side or the rights and the dignity of the other. And we've got to learn to have those things coexist.
You know, the originalists, the folks who really believe that we should be interpreting the text of the Constitution as close to what the founders would have wanted it, they're going to say this is how the framers actually designed it. But you argued in your book last year that this was not the design.
No, that's a very narrow view of what the framers had in mind, even. And I don't count myself among originalists, but even on an originalist view of how you think about rights, the framers believed in what would have once been called the state police power. That the state has the power to pursue the general welfare, to pass laws for health and safety. And that's totally consistent with the idea that we have rights. Someone has to decide whether the state goes too far, so the state can't do whatever it wants. But when you have very important interests on one side, but also basic rights to self-government on the other, judges have a role to play in trying to figure out where the balance is between those things. And sometimes you have to work that out over time. The framers fully understood that. But we've come to a place where the court doesn't believe that. And so you end up awarding victory to one side and really ratcheting the stakes of politics up very high, rather than kind of working out over time where that reconciliation between our rights should be.
So what is the effect then if the Supreme Court is either perceived to be or is a political body? What does that do to the balance of power that the framers intended, how we have methods to redress?
Viewing the court as a political body is, I think, in some ways necessary, because the court makes political decisions. So the court makes decisions that help to govern us. And that, in that sense, they are political. What the problem comes in when the court's decisions are perceived as being partisan, perceived as being holding water for one side or the other, whether it's the Democrats or the Republicans. And when that happens, you really have a court that's simply serving the one side or the other in a partisan battle. The American people are not going to tolerate that for very long. We have other institutions that engage in partisan fights. And I really think the court is sacrificing some of its own legitimacy when it's perceived in this way. We all have different views. Judges have different views than each other. I have different views than the court. You and I, no doubt, have different views about how to understand our rights, how to understand the Constitution. But it's exactly for that reason that the role of the courts should be, and for a long time has been, to lower the stakes of our political conflicts rather than to raise them, not to align one side or the other in a partisan fight with what the Constitution requires, because that at that point, the other side loses their stake in the constitutional project. And that's not very good for the health of a nation.
So just this past week, we had a couple of cases that seemed to sort of pull against each other. On the one hand, you had the gun rights case that where the Supreme Court kind of decided to overturn some of the power that a local jurisdiction could have in the case of New York. And then the next day, you had the abortion case where it was almost the opposite, that let's kick this back down to the states.
Well, you have a situation where if you only look at these cases through the lens of, is the legislature the decider or is the court the decider? It looks like the court is doing something very different in each of these cases. And you'll get criticism of the court accusing it of hypocrisy. And you'll get criticism the other way saying, well, of course, if you say they should come out the other way, you're also being a hypocrite in some sense. But what I think you're really seeing is a court kind of toggling between two extremes, because it doesn't believe, or seems to not believe, that there is some reconciliation between values that are on either side of a conflict. So in the gun control case, there's a conflict between public safety and a conflict between gun rights, and the court awards the answer to the gun right side. And in the abortion conflict, there's a conflict between the potential life of an embryo and the rights of pregnant people to control their reproductive freedom. And the court essentially says there can't be a right on the side of the pregnant person because there's a value in fetal life. That hasn't been the law of abortion for almost half a century to Roe versus Wade. That what hasn't been the law of gun control for hundreds of years of our existence. We work these things out over time through politics, also through court decisions. This is how we govern ourselves, through a combination of political decisions and decisions by courts. What you're seeing here is the court stepping in and deciding that one side or the other is going to get total victory. And that's a very dangerous thing in a democracy.
What did you learn from reading the opinions, both of Alito and the concurrent opinion of Thomas? And Thomas went further than Alito, saying that the court should revisit things like contraception and same-sex marriage.
Well, the Dobbs decision, that's the abortion case, really goes much farther than any opinion has ever been written about this subject, and that includes the dissenting opinions in Roe versus Wade. Those dissenting opinions said that Roe versus Wade goes too far, and that's not an uncommon view, even among people on the left. But the idea that the alternative to that is that there is simply no constitutional value at all in the ability of women, the right of women to control their whether they become parents or not, is an extreme position. There's no way around that. And it's really, if you look around the world, if you look at our particular history, it's a startling denial of significant constitutional values. And again, you can say that you have problems with Roe versus Wade, you think it goes too far, but to go entirely in the other direction is to deny women agency over their lives. In the gun control case, you also had what I think is a startling suggestion on the part of, not just suggestion, but it's the law now on the part of the majority, that public safety has no relevance to whether a gun control measure is constitutional or not. The only question is whether it's a traditional way in which guns have been regulated or not. Again, that's a startling a denial of agency and self-government to the American people of today.
We also had a couple of cases that from the outside seemed to blur the lines between the separation of church and state. We had one ruling where tuition assistance programs in Maine need to also be able to fund religious schools. And then earlier this week, we had a case where a high school football coach was, in fact, according to the Supreme Court, within his right of free speech to exercise prayer on the 50-yard line after high school football games, and the school district was found violating his rights. When I'm looking at this from the outside, am I saying, wait a minute here, is there a risk of either any one religion or religion creeping into matters of how we collectively hold ourselves?
Potentially, yes, the court is certainly giving more leeway to what the majority views as the religious freedom of particular people. these are quite complicated issues in the sense that the Constitution has both a free exercise clause that gives religious freedom to individuals, but also an establishment clause that says that the state should basically be out of the business of religion. Those are sometimes very difficult to reconcile when you're talking about, in one case, a public employee, a public school teacher, and in another case, a public tuition assistance program. What I think you're seeing is a court that is very reliably on one side of the political spectrum, pushing its advantage very aggressively. We're going to have lots of disagreements as a people about how to balance the establishment clause and the free exercise clause. And I don't perceive the court as doing something especially radical in those cases, but I do think that you're seeing the result of a 6-3 very conservative court, where the Supreme Court is arguably the several of the most conservative judges in the entire country are sitting on the Supreme Court. And that's a very unusual situation, and really does shape our perception of the court as being a political or partisan institution.
You know, and I wonder, some of the critics push back and say, would these cases have turned out differently if the religion at the center of that prayer wasn't Christianity?
Well, I won't speculate about what the court would do if we were talking about another religion. There are cases in which the Supreme Court, including the court's conservative majority, have upheld the rights of Muslim prisoners, for example, or people on death row who are not necessarily Christian. I will say that in general, when courts give leeway for people to do things like engage in school prayer at a public school, the result of that, given where we are as a country, is that people who practice more popular religions are going to have the leeway to practice those religions, and people who practice less popular religions may not have that leeway. So the person going to the 50-yard line and praying to Allah or engaged in a Hindu prayer of some kind is not going to get the same reception from the audience, and so that's why you don't see that happening, right? So in some sense, by default, you end up privileging one religion or another. But I won't speculate on what I think the court itself might do in that case.
Should any single individual have this much power in a lifetime appointment that's an unelected role?
Well, you're seeing people ask those kinds of questions in ways in which they haven't in the past. I think exactly for the reason that the court is so reliably on one side of the political spectrum, so seems to be carrying the briefcase of the Republican Party. If you look around the world, the idea of a life-tenured Supreme Court or High Court is extremely rare. The only other country in the world that has a life-tenured Supreme Court is Iceland. Every other country in the world either has a retirement age or has term limits. We also have a very small Supreme Court, and our Supreme Court also hears all of its cases, what's called en banc. So at the same time, all of the justices hear all of the cases. And what that means is that the law becomes extremely individualized and personalized, where in every case you have your justice in the middle. And what does Kavanaugh think? What does Roberts think? Becomes the question, as opposed to what is the law? Have a much more impersonal approach to the law in many other countries. Again, I think it's not very healthy for a democracy. It feels almost like a monarchy when you have a very small set of individuals with life tenure deciding extremely important questions central to our values, central to self-governance, and doing it over 30 or 40 years, and then deciding the timing of their retirement so they can pick the ideology of their replacement. That is no way to conduct a democracy. And if we were starting from scratch, there's no way we would do it this way.
You take time in your book and you point out that other countries do this very differently. I mean, you talk about, for example, abortions exist in Germany. How do they solve this situation? How do they balance these rights, or how do they mediate through these solutions?
Well, it's very ironic in that the German Constitutional Court, and it's not alone in doing this, when it comes to abortion rights, they had a very controversial abortion case back in the 1970s, just as we did in the United States to throw. They had a very controversial abortion case in the early 1990s, just as we did with a case called Planned Parenthood versus Casey. And the German Constitutional Court insisted then and insists now that the value of fetal life is a constitutional value. So in the United States, that codes as an extremely conservative position and would suggest that abortion not only can be regulated by the state, but maybe must be regulated by the state. But in Germany, what that meant was that there has to be some reconciliation between the value of fetal life on the one hand and the conceded value of women to control their destiny on the other. What that's led to in Germany is political negotiation around what it takes to make abortion a meaningful choice for people, which ends up redounding to the benefit both of women trying to choose how to structure their lives, but also fetal life. So how do you encourage people to choose life? Well, you give them social support, you give them paid leave, you give them paid childcare, you give them employment guarantees. That's where the political negotiation has happened in Germany. And I don't think I need to say that that's a more healthy thing to negotiate about politically than to see who can take people's rights away as quickly as possible. There are other ways of thinking about rights where courts force people to the table, force people to negotiate. Don't just hand a victory to one side or the other, and you can end up in a much more healthy place.
Professor Jamal Greene, thanks so much for joining us.
Thank you.
And finally, in that increasingly divided Supreme Court, a torch is passed. Moments ago, 51-year-old Justice Ketanji Brown Jackson, the first black woman appointee, was sworn in by Chief Justice John Roberts and the outgoing Justice Stephen Breyer.
I, Ketanji Brown Jackson.
I, Ketanji Brown Jackson.
Do solemnly swear.
Do solemnly swear.
That I will administer justice.
That I will administer justice.
Without respect to persons.
Without respect to persons.
And do equal right.
And do equal right.
To the poor and to the rich.
To the poor and to the rich.
And that I will faithfully and impartially.
And that I will faithfully and impartially.
Discharge and perform.
Discharge and perform.
All the duties.
All the duties.
Incumbent upon me.
Incumbent upon me.
As an Associate Justice of the Supreme Court of the United States.
As an Associate Justice of the Supreme Court of the United States.
Under the Constitution.
Under the Constitution.
And laws of the United States.
And laws of the United States.
So help me God.
So help me God.
And now, on behalf of all of the members of the court, I am pleased to welcome Justice Jackson to the court and to our common calling.
A liberal appeals court judge and former public defender, Justice Jackson joins a bench in turmoil, as we've been discussing. Yet her addition also means that 4 women will simultaneously serve on the court for the first time in its 233-year history. Jackson takes the seat of the 83-year-old Breyer. During his 27 years on the bench, Breyer was a steadfast supporter of abortion rights, the environment, and healthcare coverage. His legacy is also one of collegiality. Even as the divisions all around deepened, he often looked for compromise, as he told me last September before announcing his retirement.
When the public that elects the senators and the congressmen comes to the conclusion that they want to see less fighting and more agreement, that will happen. That the senators and members of Congress ask the questions and take the actions that they think, by and large, their constituents want. And so when I'm talking to the college students, I say, my friends, I learned from Senator Kennedy one thing that I think is important, and maybe more, but at least one, and that is listen to people who disagree with you. And if you listen long enough, you'll find on something they agree with you. And then when you get that, you say, let's work with that. Let's work with it. And you work with it and try to produce something positive, something that maybe gives you 30% of what you want, but better 30% than 100% of nothing.
What a radical thought. Compromise to get things done. You can see the full interview at amanpour.com.